Hi, and welcome to Is That Even Constitutional? This is a show where we use the lens of the Constitution to dissect current events, selected from recent federal administration actions, headlines, listener questions, or interesting legal issues that we identify ourselves. My name is Sadena and I am not a constitutional scholar, but lucky for me, my friend Ken Thomas is. Hi, Ken. How are you?
Hey, Sadena, how are you?
I am doing all right. It's been a rough week, and so I'm really excited to talk to you about some of the things going on, and it gives me a little bit of a reprieve to be able to have this conversation and realize that the maddening is truly maddening and not just in my head. I will say Ken was a legislative attorney at the Congressional Research Service for over 30 years and was the person that members of Congress would go to when they had a question about the Constitution. And really excited today to dive into Trump's executive orders, what an executive order is, what powers reside for the presidency within the Constitution, and maybe take a closer look at a couple of executive orders that have been coming up in our conversations about constitutionality, legality, that sort of thing. So with that, I want to start off, Ken, and just ask you, what powers does the president have in the Constitution? What are the constitutionally allocated powers for the president? Can you tell us a little bit about that?
Okay, no, that's a great question. I think that the conversation that has been going on around executive orders is often done without really the context of what the president's actual legal powers are. Now, if you look at the three branches of government, the Congress, the executive branch, and the courts, the president actually exercises a lot less power than people seem to think he does. Most of the power of the government actually resides with the United States Congress. Article 1 provides that Congress shall exercise all the legislative power, and it not only lists a very extensive list of those powers, but it also provides that Congress shall have all power necessary and proper to exercise all of the previous powers that have been listed. And then there are powers that aren't even in Article 1, such as in the 14th Amendment, that provide additional powers that Congress has. Once Congress has instituted those powers, then it may delegate those powers elsewhere in the government, especially to the executive branch. So now, moving to the executive branch, the powers that are delegated to the executive branch can be delegated either directly by the Constitution or they can be delegated by Congress. Now, there are certain powers that are given directly to the president, and the really most significant one is the authority of the president to appoint agency officials. Now, the authority to appoint agency officials does not mean that the president then gets to directly tell the agency officials what to do. Now, obviously, the president is going to appoint agency officials who in general are going to agree with him. However, that is a little different from him actually having the direct authority to run the agencies himself. So to some extent, the president will tell or will direct or will leave the agency officials to make up their own mind regarding what can be done at the agency level. And then the agencies are actually the ones who implement that. Then there are some authorities that the president does have. Some of those are granted by the Constitution. For instance, the authority as commander-in-chief, which is the authority over the military, that's something the president can exercise directly by himself. So, for instance, President Truman, when he desegregated the military after World War II, he could just do that by directing the military to desegregate, and that was something that he could do under his direct authority. Or when President Trump is raising tariffs, he's actually doing that under a national security power that has been granted to him by Congress. And again, that's something that he can do directly. But those are narrow examples, some things that presidents can do directly. And the real power in the executive branch is actually the power that is given to the agencies. And so sometimes you just have to keep an eye on the difference between those two powers. And then, of course, the judiciary has its own powers, which is to look for what the relationship is between the president, or one of the things they do is to look for the relationship between what the president and the agencies are doing and what Congress or the Constitution allows them to do. And then that's where the court's power comes in, which is they get to make that call as to whether the president or the agencies are acting within their authority and acting within their limits.
Yeah, that makes a lot of sense. And I remember I served in the Obama administration, and there was a refrain, "The president is not the king." And so that recognition, acknowledgement of the Constitution and that separation of powers was inherent in that statement, and also that kind of narrow scope of what the executive actually has. So where do executive orders fall into this? You talked about the power to appoint agency heads, and then you talked about some of the narrow things that the president can do within the military context. So where are executive orders within all that?
So executive orders are interesting. In a normal administration, executive orders actually do not receive a lot of attention, and that's because they are generally seen as just directions to agencies to how to organize or how to engage in normal agency activities, how to implement particular executive priorities, things that are really much more internal, things that wouldn't normally even rise to the level of the public attention. Under the Trump administration, the executive orders have risen to a level that's perhaps a little more sensational. And the executive order, what is it officially? Officially, executive orders are actually pretty straightforward. They're any document with the word executive order written on it that is published in the Federal Register and that comes from the White House. And that's pretty much it. And so an executive order can include anything from essentially a press release, meaning that it's just an announcement about something that the Trump administration thinks is important. It can be an announcement of an initiative, meaning that the White House would like the agencies to undertake something. It can be an announcement of the exercise of a direct presidential authority, but you also can find that some of these announcements can not be executive orders, but they can just be executive actions, or they can even be agency memos that are announcements of the same thing. So the fact that something is labeled an executive order doesn't actually give it any additional legal credence. It doesn't increase the presidential authority. It doesn't increase the agency's authority. And it doesn't mean that the executive order isn't limited by statute or limited by the Constitution as to what it actually can do. In the case of the executive Trump orders, there's also a significant number of these orders that would appear to be announcing initiatives that are not within the statutory authority of, in many cases, the agencies. And consequently, these orders are being almost immediately challenged by litigants who would be negatively affected by their implementation. So in some cases, these orders are actually indications of the agencies or the administration taking actions that appear to be in violation or outside the authorization of the agency's statutory or constitutional authority.
Yeah. And so what happens if an agency head or someone was not to follow an executive order?
That's a really great question. So legally, there may well not be any problem with that, or shouldn't say any problem with that, but there would be no legal recourse. And what's interesting is you'll see a lot of these executive bottom orders. At the bottom, there will be language saying this order does not give any legal rights to anybody. In other words, you can't sue based on this. The executive order does not give rights to anybody, and that is probably generally correct. What can happen is essentially a political result, and the political result would be that agency official could be fired. Now, what's interesting about firing of agency officials is that, first of all, the power to appoint agency officials is a power that is textually in the United States Constitution. Now, for those people who believe that textualism is the best way to read the Constitution, it can be a little surprising to find out that the United States Constitution provides that the president can appoint agency officials with the advice and consent of the United States Congress, but there's nothing in the United States Constitution that the president can fire agency officials. That's actually based on Supreme Court case law, finding that the power to appoint officials implies the power to fire agency officials. So, assuming that is still a good law, which everybody assumes it is, then the President Trump could choose to fire an agency officials who does not comply with the executive order or doesn't comply in a way that he seems is appropriate. Now, there is a subcategory of agencies that are called independent agencies. Now, most of the major agencies we think of, such as HHS or Department of Labor, Department of Justice, those are cabinet agencies. The presumption has always been that cabinet agency officials are vulnerable to being fired by the president. There is a category of agencies called independent agencies. They tend to be more commission-based agencies, such as the Equal Employment Opportunity Commission or the Security and Exchange Commissions. They tend to have voting commissions, and they tend to have more quasi-judicial or quasi-executive. They have functions that are generally quasi-judicial functions that are functions that look a little bit more like a court, and they are generally considered not to be amenable to being fired by President Trump. Now, President Trump has fired a number of independent agency officials, and that is something that we are probably going to talk about in a later podcast. But in general, the response or the result of an agency official not complying with the executive order would be for him to be fired by President Trump.
Okay. And then I just realized you said that within the Constitution, the president can appoint the agency head, but the president is not creating the agency. Is that right?
That's exactly right. So one of the executive orders that has been issued was creating the DOGE, which is the Department of Government Efficiency, which has been headed by Elon Musk. And the question has been rose is can DOGE be created by President Trump? And so there is litigation ongoing over that. The stance of the administration is that DOGE is not a government agency, but that DOGE is actually an advisory committee or an advisory board to the president, and that is not exercising the kind of power that would normally be associated with being an agency. The problem with that is that there is no funding source for DOGE provided by Congress, and that the funding source that is being provided is the kind of funding source that is normally allowed only for agencies. It's a money sharing agreement between agencies that is not normally allowed for advisory groups. And so there is unlikely to be litigation over that. And so it's not even clear that DOGE is going to be allowed to operate, at least in its present relationship.
Yeah. Okay. That's helpful to hear, and also very confusing, right? You're creating an advisory body called a department, but it's not a department. They're working on kind of financial matters, but they can't receive money from an agency. And so the whole setup doesn't make sense in that way.
Yeah, this is administrative law, which is, believe me, if you remember from law school, not one of the easiest classes.
And so I think there's also these executive orders that are threatened to cut departments down. So if the president cannot create departments like DOGE, then, what about some of these executive orders that are saying the other side?
Yeah, one of the executive orders that was released recently was essentially saying that the Department of Education should be abolished and should be abolished by the executive branch without input from the United States Congress. Now, the United States Congress has the authority to create agencies. I happen to be working on Capitol Hill. I was an intern. I was actually working for Congressman Tom Downey when the Department of Education was created. At that time, there was an agency called Health, Education, and Welfare Department, and the E was it was HEW, and the E was, of course, for education. And so the hearings were held as to whether or not the E in HEW should be spun out and a separate department was made. And essentially, that's what happened. The E didn't even go very far. The buildings were right across the street from what is now HHS, and essentially the functions that were in HHS that were related to education just moved across the street. And there were the kinds of functions such as dispersing student loans, providing money to low-income students, to disabled students, enforcing civil rights laws in the educational context. And it was the Congress that created the Department of Education. Now, there was very early in the history of the Constitution and our Congress the idea that maybe the Congress would delegate the authority to create agencies to the executive branch, but the decision was made that no, Congress was going to keep that authority to itself. And historically now, for centuries, that is where the authority has lain. And the United States Congress is the one that creates agencies, they create them, they give them powers, and if they abolish or reorganize them, that is a power that Congress has kept to itself. And in terms of the Department of Education, it is very much the case that both parties have always believed that the Department of Education, if it was going to be abolished, it would be done by legislation. President Reagan introduced legislation or had legislation introduced to abolish the Department of Education. Legislation was just introduced within the last few weeks to abolish the Department of Education. And there were many pieces of legislation introduced over the various years. So obviously, everybody on Capitol Hill believes that the department can only be abolished by legislation. And so the executive order would seem to be ineffective to have that final result.
That's fascinating. I feel like, and you've said this many times before, executive orders can be a bit of glorified press releases. And so seeing kind of the way that it's shifted narratives around the Department of Education and all of these other kind of agencies, the threats to funding, it does feel like it's covering some of its intended purpose of changing narratives, but it's not legal, right? And so we're seeing pushbacks on the power that it has, and we're still left to think about what was accomplished by the executive order going out. And I think there has been harm, but hopefully there's also a renewed interest in protecting some of these institutions. I'm wondering if you could talk a little bit about the executive orders that led to some of the funding freezes and then the injunction on the funding freezes. Could you talk about those a little bit?
Yeah, so I think that the OMB memo that was issued regarding funding freezes is a good example of how the implementation of the executive orders has run into problems. So there were a number of executive orders that dealt with the possibility of canceling some federal funds. And then both in the context of grants and contracts, OMB, the Office of Management and Budget, issued a memo essentially freezing all federal funding for, in theory, a short period of time for the various agencies to decide how they were going to move forward. And this was suggested that this was in order to just figure out how to implement these executive orders. There was an immediate lawsuit saying that this was not a proper way to implement the executive orders, and a federal court immediately suggested that this was correct. And what was the basis for this lawsuit was the Administrative Procedures Act. The Administrative Procedures Act, again, this is classic administrative law, says that agencies cannot act in a way that is arbitrary or capricious. In this case, the court found that freezing all agency funding without any regard for what the agency funding was for, what the context was, whether it had anything to do with the executive orders, there was not any relationship between the theoretical basis for the freezing and the underlying facts. And so this was found to be arbitrary and capricious. And so the court essentially said that this could not be implemented, and OMB withdrew the funding memo, and essentially the court ordered that the suspension be terminated. The Administrative Procedure Act is one of the primary statute that is being raised in a lot of these cases. It's not even necessarily that once the courts reach the merits that some of these executive orders aren't going to be implemented. It's just that if the executive orders are being implemented in a manner that is rushed, that is not with due consideration, that is not following procedures, then the court is going to say that these actions are going to be struck down, suspended, stopped from being put into action until such time as the agencies go back and do it correctly.
Yeah. And something that's interesting about the Administrative Procedures Act to me is last year there was that Supreme Court case, Loper Bright Enterprises, that took back Chevron deference. So 40 years ago, there was the Chevron case where agencies were given deference for their interpretation of how they should be regulating. And then last year, there was a court case that took away that deference. And I think a lot of us sweet summer children were like, oh, what's going to happen in the next administration when the agencies don't have as much power because of the Supreme Court case? And now I'm wondering, wait, why? I thought I was afraid of like the executive branch not being able to retain power because of the Supreme Court case, but now these agencies are going into arbitrary and capricious territory and doing what they want anyway. So it's just amusing. Maybe not a question unless you have a response, but just about how this is playing out with agency actual authority.
Yeah, no, I have already seen legal analysis suggesting that in a lot of cases, there are going to be very difficult arguments for the Trump administration going forward because a lot of these you can make a lot of administrative law arguments that are rather expansive. And I think one of the quotes from at least some of the cases regarding essentially the major rules doctrine, which is that you can't fit an elephant into a mouse hole. You can't take a small exception and then take this entire legal doctrine and put it into that mouse hole. That's where you end up with a lot of these administrative law arguments where you take what appears to be a small space inside this language and then you just try to fit a whole new area of law into it. That's going to be hard. There's so much of that is already happening with these executive orders. So I do think that the lack of Chevron deference is actually going to make it harder for the Trump administration to win in court.
That's helpful to hear. And I think it's so important for the people and the institutions that are affected by all of these cuts and the pressures and the freezes and the unfreezes to support the litigation and to support the movements that are upholding the law in this moment, because it feels so tenuous to just have it all based on will the court decide. I think there is this piece of like political pressure that needs to be stood up while these cases are going through the courts. I am wondering maybe the last thing that I wanted to touch on, and you touched on a little bit already, but just about all of these, still on the topic of the federal spending cuts and why this administration believes they can do anything in regard to federal spending. So there's DOGE, there's the OMB memo, there are the agency heads actually just getting rid of entire components of the agency like USAID, or I know HUD has cut some crucial TA, things like that. And so could you talk a little bit about that? Why does the executive feel like they can do whatever they want in regard to federal spending?
Yeah, there is an overarching theory that used to be an academic theory, used to be relatively obscure and not taken seriously, which is the unitary executive theory. And that is the thought that there is an almost inherent power of an executive to control everything within the executive branch. And what's interesting, again, is that if you're a textualist, then you work really hard to find this anywhere in the Constitution. The Constitution really provides the executive branch not a lot of power. Article 2 is a very short article. That is the article in the Constitution that provides the executive power. And it really feels much more, again, as you're saying, the theory is that the president is not king, but there's this feeling that within Article 2, just the fact that the word executive means to execute, that the president has a lot more power than he does. And so within this unitary executive theory is the idea that the president actually does have a lot more power to basically fire independent agency heads, for instance, to exercise a lot more authority than the courts have let him. And a couple of very significant parts of this are, for instance, the authority of the president not to spend money if he doesn't want to spend money. Now, this has been an issue over a number of years. President Nixon wanted to not spend money as a way to basically do his own budget priorities, but as also as a means of deficit protection. And this is called impoundment. And there was a case law. The Supreme Court heard a case on this, and Congress passed the Impound Control Act, and ended up everybody agreeing, the Supreme Court and congressional legislation agreeing that no, the president doesn't get to decide. If Congress appropriates money, passes authorizing language, appropriates money, and that money is sent to the executive has to spend that money. The executive cannot decide that on their own that they're going to pick and choose that whose money and what money they're going to spend. And so, for instance, a president can't just decide, no, I'm not going to have a military this year. I'm just going to put it all into food stamps. Or, oh, this year, we're not going to have we're going to close the national parks and we're going to put all that money into agriculture support. That's just not an authority the president has. And it seems like a pretty straightforward application of the fact that Congress has the authority to tax and spend. But this is an authority that it appears that President Trump, he thinks he has. As a matter of fact, he was impeached for this purpose. He withheld money from the Ukraine because the Ukraine refused to investigate Hunter Biden and President Biden's son for what President Biden believed was information that could be used against President Biden in the election. This is the unitary executive theory, and it is a very strong executive theory, and it is a theory that going forward would include a lot of powers that are not supported by Supreme Court case law, not exported by constitutional textualism, not supported by history, and it's essentially a very different way of looking at the Constitution. And it really is, as I said, it used to be an obscure legal theory, but it's very front and center today.
That's nuts. So thanks for sharing that, Ken. I know in our household, as we talk about this, one of the things that's scary is what's happening now, but then also the precedents that it's opening for if we get out of this. Are all presidents going to exert this chaotic influence that has never existed for them previously? What does that look like for the U.S. moving forward if we get out of this? And it's humbling to know that there's this theory that is being tested right now, and whether we'll be able to put it back in the box and in the books rather than in practice will be yet to be seen. So I think we covered a lot of ground today. We talked about what authorities live within the Constitution for the executive branch, for the president, a little bit about where executive orders fit into that and what they are. I talked a bit about a few executive orders, specifically DOGE and the other ones to cut funding that were enabling the funding cuts, and landed on this part about where we think the president or the executive or everyone that's advising this moment may be getting some of their theories on this broader power that they're trying to exercise. I'm wondering if there's anything else you think we missed, you want to add before we close out here.
Yeah, I should say that although I am speaking to some very broad suggestions that are found in these executive orders that may not survive constitutional scrutiny, that's not to say that there are not a lot of very large changes that are absolutely possible to be done if the administration pays more attention to working within the statutory restrictions that are on them, the constitutional restrictions that are on them. There are actually a lot of things that a president can do and has done in the past. President Clinton actually reduced the federal workforce through attrition. The borders are actually a place where a president can exercise significant amounts of authority. Reorganizations of agencies can lead to rifts that can lead to people losing their jobs. There are actually very significant changes that can be wrought. It's just that we have been seeing a very haphazard approach to these kinds of very significant changes. And in some ways, the haphazardness has really been almost self-defeating. So I don't want to minimize what could and may well happen going forward by suggesting that some of the initial efforts have been and may well be limited by the courts. This is very early in the administration, and there is still potentially a lot of things to go forward. And the best thing to do is stay informed, keep an eye on what is important and what is not, and what is likely to be of most concern going forward.
That's a great frame on it, Ken, to realize they're taking the actions that they can now, whether they're legal or constitutional or not. But there are certainly a lot of actions they can take over the next still pretty much 4 years to be able to do this in a constitutional and legal manner. Appreciate that. Thanks for chatting with me today. That is the end of our episode. For everyone listening, we hope you continue to listen, to share, to subscribe, to find us wherever you find your podcasts. Music is courtesy of Ken Thomas. We look forward to hearing listener questions to help guide future episodes. And until next time, thanks for listening to Is That Even Constitutional?
Thank you.